exceeds the termination period, my lord, then there may be some problem, my lord.
What is the age of the fetus?
My
now?
lord, I think it is 3 months now, my lord. Still within that termination of pregnancy act, my lord.
All right, but you know this matter can wait till Monday.
My lord, then my lord can Monday.
Monday,
My lord,
yes.
obliged.
May I please, your lordship, I beg to mention item number 7 and 8, lordship, only possible for the day, lordship,
7 and 8.
lordship,
Why? You are appearing for whom?
petitioner, lordship, and
You have informed the other side.
lordship.
With the consent of the opposite party, Ms. A. Begum, learned counsel appearing for the writ petitioner in both these cases have sought adjournment of admission hearing of these matters with a request to post these cases again after 4 weeks. Since the prayer is not opposed, same stands allowed, list accordingly. Yes.
May it please your lordship. Lordship, I would to mention for listing of a writ petition, lordship,
Hmm.
the matter pertains to the no confidence motion against the petitioner,
Hmm.
president of the Gaon Panchayat, lordship.
Hmm.
And the matter was last listed on 15 March 2023.
So what does the registry say?
Lordship, the matter was directed to be listed for orders, but the matter has not yet been.
Now, have you asked the registry why?
No, lordship.
Why don't you do that?
Lordship,
They may have a reason.
lordship,
After that, you come.
lordship.
Yes.
For motion item 1 to 3.
In item 2 and 3, I am filing a affidavit today, lordship. And one will also cover that item 2 and 3. Maybe taken after 2 weeks, lordship.
Mr. S.C. Kyle and a standing council GST authority submits that he is in the process of filing a counter affidavits in item numbers 2 and 3, which will also cover the issue involved in issues raised in item number 1. As such, a prayer has been made to post these matters again after 2 weeks. Since the prayer is not opposed by you are for the petitioner.
Yes, my lord.
Your name, please.
H. Jane,
H.
Jane,
Not opposed by Ms. H. Jain, Learned Counsel appearing for the petitioners. The same stands allowed. Let the matters be listed accordingly. Interim order passed earlier to continue.
obliged, madam.
For admission item 4 to 6.
Lordship, 4, 5, 6 is a matter relating to service tax. In 2 matters, we file our affidavit. Lordship, there is a question of maintainability also. May I put some other matters, lordship, fixed up to 4 weeks. The number of the case is WPC 1580 or 23, lordship.
WPC number
1580 of 23.
Lordship,
any objection?
lordship.
Mr. S. Chetil and counsel is present on behalf of the writ petitioners. Mr. S.C. Kyle Lanet, standing counsel GST
GST.
authorities submits that similar writ petition raising similar issues, a similar nature of issue is fixed before this court after 4 weeks. And therefore, a request has been made by the learned departmental counsel to post this matter along with WPC number 1580/2023.
Lordship.
You are for whom?
I am for item number 1, lordship. My senior is stuck on the traffic.
All right, Mr. S. Chotia for item numbers
Item number 5 and 6.
5 and 6 and
Item number 1,
one we already passed.
my lordship, I am appearing for item number 4. Item number 4.
Achha, Miss H. Jain for item number 4. DD Bopar, huh? Miss H. Jain for 4, Miss S. Chotia. Since the learned counsel for the writ petitioners do not have any objection if the prayer is allowed, same stands granted. Let these matters be listed along with WPC number 1580/2023. Any interim order?
Lordship.
Yes,
Interim orders operating in these cases shall continue until further orders.
Much of it.
What is your name?
P. Talukdar.
P. Talukdar, item 1, give her name, P. Talukdar, and 2 and 3, H. Jain.
Lordship, on behalf of Dr.
Achha, you are appearing for whom? The respondent.
Lordship,
Oh, then respondent in item 1 is Dr. B.N. Gogoi.
yes, lordship.
And item 2 and 3, Mr. S.C. Kel.
2 and 3 will cover.
Achha. And petitioner's counsel is H. Jain, Miss H. Jain for all the 3 petitions. Yes.
Obliged.
For hearing item 9.
Yes.
Should I file this petition?
Hmm.
Selling the land acquisition proceedings initiated in respect of 6 PLA cases. And a prayer was made not to take any action for in respect of PLA case number 12 of 2006.
What is
Echo.
PLA case?
PLA cases are, my lord, 10 of 2004,
What is the meaning of PLA?
permanent land acquisition.
Hmm,
May I give the numbers, my lord?
yes,
10 of 2004, 3 of 2006, 12 of 2006, 8 of 2007, 1 of 2008, and 6 of 2010. And in the writ petition, interim prayer is made not to take any action pursuant to the notice issued on 12/8/2012 in respect of PLA case number 12 of 2006. This honorable court issued various orders, my lord. It is necessary to take your lordship to those orders, my lord. Your lordship may kindly first come.
one writ petition deals with all these cases.
5 cases. Your lordship's order is also there.
No, what order is there? Let us see.
First order, your lordship will find it.
Mr. Kejriwal, you have to choose. We'll only deal with one PLA case in this writ petition. These are wrongdoings.
My
We'll
lord.
not allow it.
My lord, in respect of one that is 12 of 06, they have abandoned. So no cause of action survives in the present petition. They have already abandoned. That is reflected at page 253, running page 253 of their affidavit, my lord. They have stated that the acquisition proceeding is abandoned. So no cause of action survives, and this is confined in respect of only 5 PLA cases. And from their document, I will show, my lord, there is violation of section 4, section 5A, section 6, and
No, Mr. Kejriwal, this is a question which is frequently confronting the court. You are challenging the validity of 6 different PLA cases, right? You may have a similar nature of grievance. But are you not required to file different writ petitions? If one of the cases you don't make out, we'll dismiss the entire petition. I'm making it very clear.
yes,
We'll dismiss. And there is no question of quashing these cases here. These 2 things I'm making it very clear. 5 cases cannot be
my
quashed.
lord, in fact, my prayer is limited on the basis of the documents filed by them, since there is non-compliance of section 9, because notification under section 4 was issued under section 17(4).
Let us see what is your prayer.
Lord, I have more the relief, my lord, in my petition because of the documents filed by them, my lord.
You already got the relief.
No, my lord, I have changed the prayer, my lord, in my petition, my lord. In my affidavit, I have made prayer that these are all violative of the provisions contained under section 6 for 5A effect.
Let us come to your prayer portion, please. Yes. Which page?
Page 29, my lord. As far as 12 of 06 is concerned, that is already abandoned, my lord.
There is an expertise award in
In
PLA.
all cases, my lord, expertise without serving any notice under section 9. And even the award is made, my lord, after 2 years of the publication of the section 6 notification in one case. And in one case, the award is made after coming into force of 2013 Act. That I will show from their own document.
You do it somewhere else. I will not write this judgment. Separate matters, separate facts. This case, this is the fact. That case, you have clubbed everything.
My lord, on the basis of the chart, I have prepared a chart, my lord.
No,
It
we'll
will
not go.
make things clear.
This is, this court is very reluctant in these matters. These are separate proceedings. You could have filed 5 separate writ petitions. Why have you clubbed these things together? Why?
Since my right to file objection claims that has not been taken care of. So the limited.
We will not set aside the award. I can only remand the matter to the authorities to consider your grievance. If you are agreeable to that order, I can dictate it. Setting aside award, not possible.
To consider my cases afresh.
To consider your grievance. But awards have been passed, separate awards passed. You're challenging all of them in one writ petition. How can you do that? Then in that case, you can send a WhatsApp message to the court. We can decide a case on that. There are some technical requirements. Is it not? If there are different land acquisition cases, one is aggrieved by an order, independent proceedings will have to be filed. Maybe that the nature of grievance is similar.
My lord, when I approached this honorable court, there was no documents whatsoever been provided in respect of any of the PLI cases. Accordingly, this honorable court has directed by various directions to place the whether the provisions of section 4, 5A, 6, 9 have been complied with or not, and to produce the documentary evidences. From the document, it is now evident that none of the provisions are come.
Yes, but
And the ex parte awards have
this
been
court has been consistently raising this issue. I'll not be. Then I'll adjourn it. You will see it somewhere else. On the request of Mr. S.K. Kejriwal and counsel for the petitioner. This matter stands adjourned for 4 weeks. Mr. B.J. Talukdar, Planet Senior Counsel, assisted by Mr. P.K. Nedhi, Planet Counsel appearing for the government of Assam, and Mr. S. Datta, Planet Standing Counsel, PNRD Assam, Revenue Department Assam, are present and do not have any objection if the prayer is allowed. Are you saying this is legally permissible? What you have done, is it permissible legally?
In fact,
You are challenging awards in different cases.
my lord, awards were filed only before this. No
But then
copy.
you argue. I'll pass an order from that. You argue. But I will consider this, whether this writ petitions could have.
Your lordship, may kindly adjourn it. Let me also check. My lord, verify. Let me also verify. My lord.
These things are creating unnecessary problem for the system, Mr. Kejriwal. But you admit that legally it is not permissible.
Had the copies of award been furnished, my lord, had the notification were.
Then we'll ask them to furnish you copies of award and give you right to challenge.
Those have been filed now. In 2017, I filed the petition in 2013.
And you want those awards to be set aside.
Look, now from the awards.
List this matter before any other bench without me. Yes, next matter, please. Yes.
Please, Your Lordship. And Lordship, my periodic patta was cancelled without any issuing any notice, Lordship. If my periodic patta was cancelled without issuing notice, initially annual patta was issued to me, Lordship, thereafter, Lordship, deputy.
Patta was cancelled by which order?
Lordship, that is annexer, page 22, Lordship, annexer 6.
This order is not appealable.
No, Lordship, because
Why?
Lordship, that is annual patta, periodic patta was cancelled.
Mr. Sharma, is this order appealable?
Lordship, perhaps annual patta cancelled, then appealable, Lordship, but periodic patta cancelled, not appealable, Lordship. My patta was cancelled and land was allotted to APDCL, Lordship, without issuing any notice to me, Lordship.
So who is in possession of the land now?
Lordship, APDCL.
They are in
Because by
possession.
this order, Lordship, they were given position, Lordship, immediately, Lordship.
So if this order is cancelled, then you will get back possession. Is that the law?
No, that is also.
Then what will you get?
But that is, there is also stay order, Lordship, passed by this honorable court. That order was also stayed, Lordship, at that 2013, Lordship.
All right.
So my prayer is, Lordship, pass an order to, after following proper procedure, Lordship, that can be done, Lordship.
What is the proper procedure?
By giving notice, Lordship, otherwise, Lordship, DC has no power to cancel. One, Lordship, section 10 of the Assam Land and Revenue Regulation, Lordship. Once patta was issued, Lordship, that
No,
cannot.
this is an annual patta.
This is not annual lordship, periodic.
In paragraph one, it mentions AP.
AP, but lordship, periodic patta was issued, lordship, I have annexed that lordship. Annexed two lordship. Two, three lordship, annexed three. Page 18. Two is the annual patta, three is the lordship periodic patta.
So, but periodic patta has not been cancelled.
Period, but lordship automatically that is also
No,
cancelled.
no, we'll not go into all this thing. The order doesn't say periodic patta is cancelled.
But lordship, that is a subsequent order, that is also not.
No. Then you have to avail appropriate remedy. You are challenging an order by which the annual patta has been.
Exactly, lordship.
And you want the court to comment on your periodic patta also. This will
It
not
is-
happen here.
It is still there, lordship.
Sorry.
Annexed three, lordship, page 18,
Mhm.
my periodic patta.
At least this order does not mention about periodic
No,
patta.
lordship. That's why I've challenged lordship, that order, that was order was stayed, lordship, in the 2013 lordship.
So that's all right. Any order passed in this proceeding will only confine to the annual patta. It can't be periodic patta. What is
Deputy
your prayer?
Commissioner has no power, lordship, after 10 years, lordship.
Hmm?
After 10 years, that was cancelled, lordship. Annual patta was issued in the year 2001, lordship. Cancelled 2012.
You must be aware, what is the meaning of annual patta?
For a particular period,
What is that particular period?
1 year, lordship.
Yes. Then what happens after 1 year?
That periodic patta was issued after the procedure.
What happens in respect of an annual patta after 1 year?
That has to be, that has to be converted into periodic patta, lordship.
No, you are not aware perhaps. That is the problem. That is not the law. An annual patta has to be renewed every year. And there is no right created over the land. It is just a license. If you pay the tozi,
Yes.
you continue. If it is not renewed next year, you are out. And the government has the right to cancel annual patta at any time. There is no need to serve notice. There are judgments of this court on that. Have you read those judgments?
No, lordship, but lordship, here what happened, lordship, after one, that was converted to periodic patta. In the present case, lordship. And in fact,
But
that
the
is,
periodic patta has not been cancelled. So
No,
we
sir.
say that there is no ground to interfere.
in fact, lordship, there is a judgment, although it is an old judgment, lordship,
Mhm.
that patta cannot be cancelled by the deputy commissioner, lordship, and
No, annual patta can be.
annual patta can be,
Yeah,
but
there is-
subsequently that patta is there, lordship, that is the problem here.
That patta has not been cancelled.
Not cancelled, lordship. Just to give the land to the APTCL, lordship, they have cancelled my annual patta, lordship. That was my case. Section.
Where have you stated that they have cancelled your periodic patta?
Oh, lordship, periodic patta not cancelled, lordship, that is only annual patta cancelled. It is the problem.
So what is to be done?
In
At
the-
present, the
in
land
that
is
case,
under the
Lordship, if the annual patta is cancelled, in that case, Lordship, most probably the petitioner doesn't have any case, Lordship. Had it
Annual
been
patta
period-
does not confer any
right.
permanent inheritable right over the land. It's just a license. The government can ask you to vacate anytime.
Exactly.
So the government will act through the deputy commissioner in a district. Who else? If your periodic patta has been, if your right flowing from the periodic patta has been tinkered with, it's a civil dispute.
Then, lordship, may I pray for lordship, I may be allowed to file one representation before the deputy commissioner,
Hmm.
lordship.
You do it, keep doing it for next 30 years.
Then-
But the law is this.
Yes, sir, I understand.
You
And
might
you
get
will
stuck
pass-
up somewhere when the law becomes clear. Then there is a problem.
He'll pass
The
necessary-
haze in the law is a very
I
fertile
understand.
ground. You can go here and there. But the moment the legal position becomes clear,
I understand, lordship.
then there is a problem. Today you are facing that problem. What do you want?
Lordship, I may be allowed to file one details representation before the deputy commissioner, lordship, explaining everything, lordship, then he will pass necessary order, lordship. Otherwise, I am also not in position, lordship. Client
Why
also not-
why don't you consult someone who knows the land law and give your client the remedy he deserves?
Then, lordship, some other
Instead
day.
of experimenting and
Yes,
exploring. here
lordship,
and
then
there.
some other day, lordship.
No,
Fine.
these are 2012, 13 matters. These are listed on top of the list.
Both the matters same, Lordship.
Anyway, you argue, let us see. You argue the case.
Some other day, Lordship, I'll try to.
Top of the.
I'll try to, Lordship, satisfy your Lordship, if something will come out, Lordship. Next week, any date, Lordship? Next Tuesday?
On the prayer of Ms. P. Bhattacharjee, learned counsel appearing for the petitioners, let this matter be listed again on Tuesday next as fixed parted matter.
Obliged,
Mr.
Lordship.
H. Sharma, learned government advocate Assam, senior government advocate Assam, and Ms. G. Hazarika, learned standing counsel revenue department Assam are present on behalf of the official respondents.
Obliged, Lordship.
Please look at the judgments. There
Yes,
are,
sir, Lordship.
you have not seen anything. You
I-
must come prepared with these things. Suddenly it's just coming and saying, there is no mention of periodic patta in the order.
Can it be taken after some time? Mr. Gupta is on his way with the brief, my lord. He's coming.
Sorry. The court is not on the leg, it is sitting, so you argue. These are old matters.
Yes, my lord.
Why are you asking for time?
No, just for time, just for 2 or 3 minutes, my lord. He's on the way coming.
Yes, what is this matter?
Cancellation of contract, Lordship.
Cancellation of contract.
Yes, Lordship.
What contract?
Yes, Lordship. The land was provided to the petitioner for doing business of the business, Lordship. And after on rent, Lordship, the rent was not given as per the conditions, Lordship. Therefore, page 43 is the order.
Page 43.
Yes, Lordship.
Sorry, my lord.
You are appearing in this case.
Yes, my lord. I have prepared a, my lord, list of dates, my lord. Some,
So who is in possession of the land?
my lord, the petitioner is in possession of the land,
Hmm.
my lord, because we have structure, we have stock of 9 crores, my lord, here, still, my lord, and we are manufacturing some poles, my lord, for road, my lord.
Yes, what we'll do is, we'll relegate the matter to the civil court and the protection will continue till for a limited period.
My lord.
In the meantime, you file a civil suit and because these are disputes arising over land, immovable property based on a lease agreement, Reed Court cannot decide these matters. That's the order I propose to pass, right?
Lordship.
Take the nod, Mr. G. N. Saiwala, and a senior counsel listed by Ms. DJ Saiwala, and a counsel appearing for the writ petitioner, also heard Mr. J. K. Goswami.
For
and
respondent
additional
2 and 3,
senior
Lordship.
Government advocate Assam appearing for respond numbers
3 and 4, Lordship.
3 and 4, Mr. A. Kalita, learned Arrange it serially. Kalita, SC Industries Department, Assam, is present on behalf of respondent numbers 1 and 2. Full stop. By filing this writ petition, the order dated 14/3/2013 issued by the Managing Director of Assam Industrial Development Corporation Limited, that is the respondent number Respondent number 3 herein has been put to challenge on the ground that the impugned order has been issued in violation of the relevant legal provisions. Full stop. By the order dated 14/3/2013, the respondent number 3 had cancelled the lease, had terminated the lease agreement by means of which a plot of land was measuring about 5,500 square meter was permitted to be occupied by the petitioner in the Export Promotion Industrial Park at Amingao for a period of 60 years. Full stop. As per the impugned order dated 14/3/2013, the petitioner had failed to pay the outstanding lease rent amounting to rupees 24,73,414 bracket approximately bracket close till February 2013. As a result of which the impugned action had to be initiated by the respondent number 3. Full stop. After hearing the submissions made by, then you write, by virtue of interim order dated
11/4/13, my lord.
11/4/2013 passed in this proceeding, whereby the respondent number 3 was restrained from initiating any coercive action against the petitioner, subject to deposit of a sum of rupees 10 lakhs. The petitioner is continuing to occupy the plot till today. Full stop. According to Mr. Sahewala, there are valuable articles belonging to the petitioner firm valued at more than rupees 9 crores, which is lying on the plot of land, and therefore the impugned action is not only arbitrary and illegal, but also violative of the provisions of section 106, is it?
My lord.
Anybody has a transfer?
106.
106 of the Transfer of Property Act. The aforesaid assertion of the petitioner's counsel has however been denied and disputed by the learned counsel appearing for the official respondent.
Lordship, there is an alternative remedy also.
You
Lordship.
take your, after hearing the submissions made at the bar, it appears that there is a civil dispute arising by and between the parties centering around the lease agreement and the rights and the right of the petitioner, if any, to continue in occupation of the land would come within the scope and ambit of section 106 of the Transfer of Property Act. What is the year you see it? What is the year Transfer of Property Act?
Transfer of property.
1952?
1946.
1952.
1946.
As such, this court is of the opinion that this matter cannot be entertained and or adjudicated in a writ petition under Article 226 of the Constitution of India. As such, granting 60 days time to the 1880, 60 days time to the petitioner to approach the civil court by instituting appropriate proceeding. This writ petition stands disposed of by clarifying that the interim order dated so and so passed in this case shall continue to hold the field for another 60 days with effect from today. 60 days or 90 days you want?
90 days.
90 days with effect from today. That's all. Now you say what you have to say.
Yes, Lordship. Page 40, Lordship.
Hmm.
Every page 40, clause H, Lordship.
Hmm.
Every dispute, difference, or question touching or arising out in respect of this agreement or the subject matter thereof shall be referred to the sole arbitration of the councillor of the district wherein the lease plot is situated, or any person appointed by him. The decision of such arbitrator shall be final and binding on the parties, lordship. The alternative remedy is there.
108, not 106. Yes, you take this plea once you file the suit.
Well.
There is a provision in the Arbitration and Conciliation Act where you
Yes.
can, before filing return statement, you take that plea. Let the civil court go into it. These are not matters for the writ court
Lordship.
to entertain.
Lordship.
Nothing.
Dispose of, yes.
I appear for the respondents in this matter, minutes. For the interveners.
Dr. Sharaf is arguing a matter. So
This is the last item. We can't help it.
May I pay for
Part
it?
two here, at least.
May I then just give your lordships a brief overview? Although, my lords, I should write at the outset, my lords, confess that I am the intervener.
Hmm.
So Dr. Saraf will definitely raise a lot of objections, but rehearse the merits as an officer, my lords.
You have been
I have already been impleaded, my lords. Pleadings are complete.
impleaded as respond number.
7, my lords. Deepak Phenolics, my lords. I am the domestic industry
Hmm.
based on whose complaint this entire BIS proceedings had initiated, my lords.
Hmm.
Well, this matter pertains to interpretation of the BIS Act or the Bureau of Indian Standards, my lords. Earlier, before the BIS Act, we had this ISI marking, my lords.
Hmm.
And in 1996, the BIS procedure came and there is an amendment in 2016. We are concerned about the 2016 Act, my lords. Now, the BIS registration is an optional thing, my lords. You are not supposed to, my lord, there is no mandatory thing, but my lord, when it comes to public health, etc., there are certain provisions in the BIS Act which makes it mandatory. My learned friend is the manufacturer of plyboard, my lords.
His client, you mean?
His client, my lords.
Yes.
My learned friend's clients are
Hmm.
manufacturers of plyboard. We are dealing here with a product called phenol, my lords. I am also a manufacturer of phenol. I'm the domestic industry. I manufacture phenol domestically, my lords. I have got my BIS registration done. The question is whether for goods, and he uses phenol, my lords, as a imports phenol and uses it in his products. So he says that the imported products should not have BIS certification, my lords, because it will affect me as a consumer of the BIS products. The registration, he says the registration that is required under the Act of the manufacturers or the certification that is required of the manufacturers should not apply to foreign manufacturers and should only apply to domestic manufacturers. The government, on the other hand, contends that the certification process is intended to standardize the particular product as far as the country is concerned. And under the various trade agreements, my lords, that is the under the WTO, etc., the government has the power to do it. Now, I had two preliminary objections as far as the writ petition is concerned, my lords. My lords, this proceeding has not culminated into an order of BIS, my lords. So what he challenges today is purely a recommendation, and he says so. It is an admitted fact. The prayer as well as prayer 3 of the writ petition at page 7, your lordships will see, clearly says, my lords, this is a recommendation that he challenges.
Page 7.
Page 7, my lords. Well, it's several paragraphs, but I'll start with page 7,
Yes.
para 3.
Mhm. Yes, please.
That the instant writ application, the petitioners are challenging. Your lordship has para 3.
Yes, yes. Yes.
In the instant writ application, the petitioners are challenging the validity and legality of the recommendation of respondent number 1, apparently taken during the course of the expert committee meeting held on so and so, so and so. And, my lords, but the bottom of the page, are in the process, last sentence of that paragraph, pursuant to such, respondent number 1 and 3, 1, 2, 3, are in the process to observe necessary formalities and notify the recommendation anytime now so as to bring the above two raw materials listed at serial number 10 in the annexure B and serial number 12 in annexure C of the aforesaid notice under mandatory BIS marking scheme under the BIS Act pursuant to the WTO agreement. So, my lords, my first leg of argument is, my lords, since they themselves admit that it is merely a recommendation, the writ petition is premature, my lords. That's contention one. Contention number two, my lords, the question as to whether a certification process has to be done or not is a domain of the, my lords, executive.
So this recommendation has been made to whom?
The recommendation, my lords, the recommendation is that I will impose or I will certify BIS. And after that, what happens, my lords? Once that order, a draft order is made under the WTO agreement, it has to be sent to the WTO. WTO then gives an opportunity to all its member nations, my lords, to give objections. It was at that stage that the writ petition was filed. If no objections are received, then, my lords, it is notified. And under section 16 of the Act clearly specifies that unless not notified, this certification process doesn't come into play. In this case, your lordships will take it from me that there is no notification issued, my lords, and my learned friend probably also would agree to that, my lords. That's one. My learned friend is here, my lords, let him take over. I was just trying to fill in for this thing, my lords.
No, you should not have, because you are interveners.
My lords, I said that, my
No,
lords.
no, your juniors wanted the matter to be
No,
passed
but you
over.
cannot start also.
No, but this is the last item. Then I will rise and then the
Milord,
board collapses.
I fully understand, Milord, you must be highly appreciate.
No, no, it's all right. He was present, so. I
Milord,
just-
I have to- no,
This is the last item in the list.
something, some time pass, Milord, something has to be,
Yes,
must be kept busy
Yes, that
also.
is exactly why
No, no, I'm obliged
I
for
took
that.
leave of the court.
I'm obliged.
Otherwise, I'll rise and then that's all for the day. So what can be done? There is no part two list also today.
Milord, this matter, in fact, if I say, Milord, genuinely, Milord, the volumes and the lectures which are there, which after going through it also, I could not finish up.
You could not?
Finish up, Milord, they're going through all these things, Milord. Details.
Huh.
Such volumes and all those things are there. My learned friend has summarized in a very short, that is not a such short issue, Milord. That a simple issue that is shortcut, that recommendation is there or not there. Because the issue, Milord, which is coming up, I may tell you, Milord. This is for the import of phenyl and melamine from outside. Outside the country, Milord. Now, what they are trying to do is making the BIS mark mandatory. There is no problem for India. They are saying that the importer, exporter, he must register himself, the exporter, with the BIS mark. Now, you'll also kindly appreciate that. The goods are coming from, assuming, Europe. One exporter is there. You can verify at the port of import itself that you will not allow it to cross unless and until it meets the BIS standard. But to say that the exporter in the country itself, he must get the BIS mark for sending the goods to India. Then what will happen, Milord? A person concerned exporter is sending to 20 countries. I'm assuming, Milord, for 20 countries have got their different marks. Now that person, the exporter, will get himself registered for all the marks. Milord, the quality control, which is necessary, I'm not objecting to it. Not a below standard quality should not be allowed at all. Similar should be for the other industries also, domestic industries also. The only reason of it is that, Milord, the import should be curtailed. The import should not be allowed, so that the domestic industry which is there, the prices of that product may go up. I may tell you, Lordship, one of the grounds which may be taken about public safety. Now, when the phenyl and melamine is coming out of the factory, it is being carried in the normal tanks, not ISI map tanks. There was a proposal that should be carried only in the ISI mark tanks, so that of safety is there.
Dr. Sarab, what is the central legal issue? We are not concerned about whether
My lord, the
so and
issue-
so should be asked to register, so.
my
What
lord,
is
the
the
issue is
central
that-
legal
The
issue?
issue is that only, my lord. That they are making it BSI mark, that person must get registered.
So in other words, you don't agree with their view.
Well, I am the importer.
Hmm.
I am the importer. Now, if the person concerned will not export for this region,
Hmm.
I am going to suffer because I have to purchase whatever price the local they sell it. I have to purchase that price.
All right, but are these matters to be decided in a writ petition?
You know, the repetition, because the question is that the section of the BISI, the provisions which are there, whether that provisions, this marking or because I am a manufacturer. I'm not a consumer of that type that somebody is consuming. I'm using in the manufacture of the products for further in the plywood industry. Your lordship will kindly, one is the consumer.
No, no,
What-
I have understood. All I'm asking you is that assuming that you have a dispute, assuming, are these matters to be decided?
Where I will go then?
No, is there no forum, this
No, there is no appellate forum.
competition,
There is no
commission,
appellate forum.
tribunal and all? They are not.
There is no
forums
appellate
to look
forum.
into this?
Well, to my understanding, there is none, my lords, but he doesn't challenge the virus of the act at all, my lords.
I am not challenging the barrister.
He says- Well, there is no other, because it is still at the draft stage, my lords.
But I will tell you.
It is not culminated and,
Well, I-
and he admits, my lord, just 1 second, Dr. Saraf. He admits, my lord, in his representation that these are all policy issues. I'll show that admission in the representation that he gave.
Who is he?
That's
to
a
say all
separate
these
matter.
things?
I'm just assisting.
He is the interested
So,
party.
so you will argue the matter today?
No, I am not going to. If you also permit me, then I take time because I'm telling you also the reason is that my learned friend is saying he's the interested party. He's the person who has filed that this should be BSI mark.
No, that's all right, but he has been
Now
implicated.
the question is that I'm telling you, Lordship, the question what is there, which is coming up for your consideration of your Lordship is that my learned friend says that this is only recommendatory. There were various items for which recommendation was made. These 2 items, your Lordship passed the order that before passing a final order, leave of the court may be taken. Nothing else.
No, no, that's all right, Dr. Saraf.
No. In all
We are
other-
not on that. He makes his submission, that's a different issue.
In court, always it refers.
First,
because-
what I'm asking is, are you arguing the matter
I'm
on
not-
merits?
not
It is
today.
listed for hearing.
No, today it's always hearing, the matters are coming before Lordship. Your Lordship may fix a
If you are not arguing it today, then.
I'm so
let it-
grateful. Well, I'll just summarize this and
Then what for? What purpose?
very well. I'll leave it
This
to
is
you.
the final hearing matter.
Yes, my lords.
Then there's no question of maintainability here.
There is a question of
No,
maintenance.
But it has been admitted to hearing.
My lords, but there is an objection on the preliminary issue itself. We had raised that. my
No,
lords,
you
but
see, the
I see what is
the
following.
court is only concerned about following a established procedure.
Correct. I see,
Nothing more, nothing less.
of course.
The writ petition has been admitted or not?
The petition has been, yes, my
It
lords.
has been admitted.
Yes, my lords.
So that order of admitting the writ petition has to be challenged. This court will not go into maintainability now.
My lords, the only
Now,
difficulty,
of course, the court may examine whether there is a cause of action.
correct,
proposed.
correct,
But whether the writ petition is maintainable or not, either it will be allowed or dismissed on merit.
correct. So I'm just arguing on merits itself, my lords. On the merits also, there are 2 broad issues. If your lordship just give me 10 minutes. my
No,
lords,
I will not
Mr.
agree to it.
Sharma, the fact is, he's seeking adjournment. You
Correct.
argue on that.
Correct.
Are you opposing his
Well, let's,
prayer?
I will leave completely since your lordship has time. So I thought I'll use some bit of the judicial time to just explain the process,
Up to 1
explain the
o'clock.
matter, my lord.
Up to 1 o'clock.
So your lordships will hear it, my lords, and whatever date your lordships will fix, I have no difficulty.
Agree on a date because you'll be traveling.
Yes,
for
my
the
lords.
matter. Agree on a
I
date.
leave it to my learned friend, my
Well,
lords.
always
I have been
want-
suffering
I
in-
always want he should come.
No, my lords, I have come enough for this matter,
no,
my
there
lords,
is no harm.
not for this matter.
No, there is no harm. More he comes, what is the harm, my lord?
No, at least the harm is not to anyone inside the court.
So far outside the court
Whether
also.
there is
no-
harm or not will not say.
Outside the court also, there is no harm. So my learned friend is concerned.
Why should be there harm? He would love to come to.
Yes,
My lords, this is my home, my lords, I would love to come,
Originally-
but
originally
this
from
is
Assam.
the matter, difficulty is, my lord. Your lordships will see there is an order of January 2020, which says because of which the central government is not passing any orders, my lords. So that is the difficulty.
Is there an interim order here?
Yes,
What-
it is
what-
interim
what-
order, your lordships will see.
What interim order is there? Your lordship can see.
Lordships will just.
Let us see.
I know, lordship may see,
What
my lord.
is there? Let us see.
Your lordship may see, my lord.
What is the date of the interim order?
My lords, 22nd of January, 2020, my lords.
So there is no restraint. Only thing is. the
Yes, but the
government is to operate-
difficulty is, my
Yes.
lords, difficulty is, my lords, the government, for whatever reason, although he says that the government and I have connived and got all of this done, etc., etc.
Yeah.
But if that is so, my lord, they would have passed some order.
How
This,
they can
I mean, I don't understand. My learned friend is a senior, my lord.
No, no, I'm senior, that's why I'm saying that, my lord.
So then I'll not argue, then
Yes,
I'll
that's
not,
what
I'm just,
I do.
then
This is what I do.
I'm just assisting the court here.
No, 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 there's no question of
Who is
assistance.
CGC here?
My lords,
Central Government
Mr.
Council.
Mr. Chaudhary is there, I believe, my lords.
Mr. Chaudhary means Architect Chaudhary.
Yes,
I've never heard that intervener making the submissions. I've never heard.
No,
my lords.
Dr. Saraf, he is a respondent now.
My lord,
He
as
has
an
been
intervener,
implicated.
your lordship, he's not a respondent, as a party respondent.
No, he has been implicated.
He has been implicated as an intervener.
As an intervener, my lord, I said
That's
so.
right. But
Yes.
now he is a.
I'm a
party-
respondent,
He's
yes, my
not a
lord.
party- he's not a party
I,
respondent.
now.
because the law says that I can argue whatever has been stated by the respondents in the affidavit.
Yes.
My
we support.
scope. I don't understand this. back
I
and-
also don't understand. This is
My
going
lord,
on everywhere.
He always, he wants an open goal, my lords. He can't have an open goal in a
But
matter
let's-
like
let's
this. my
not
lords.
get into. all
My lord,
this
yes, exactly. That's,
facts.
I didn't want to do that. my lord.
How you can say that I want an open goal? But I will not allow the other, this team also to enter into somebody else's match.
All right. Let's come to the merit. Let's-
Exactly. So, my lords, what I'm saying is that my scope of argument, my lords, is should be, my lords, confined to whatever pleadings the other respondents has taken. I cannot, my lords, as an intervener, take a plea beyond what the respondents say, and
That's
that is exactly what my argument is going to be, my lords. And just, your lordship gives me 2 minutes. They in the reply, the respondents in the reply clearly say 3 things, my lords. One, that it is purely recommendatory, my lords. It is not culminated into a notification. And section 60.
That you have already.
Yeah,
said.
I've already stated. 2, my lords, in the representations that they had given, my lord, and your lordship sees just 1 page of their writ petition itself at page 159, my lords.
Mhm.
Lordship sees that page. It is their own representation before the central government, my lords, where they clearly admit, my lords, that these are issues of policy. My lords, may kindly see the second paragraph of that page.
Right.
Your lordship has 150.
So are you seeking an order today?
My lords,
Are you seeking any order from the court today? Except
I am not seeking, I just wanted to, since your lordship said that lordship has time, I thought I'll just give a filler, my lords.
Mm.
It is necessary to clarify that FIPPI is an accredited federation of panel products industry in India by the Ministry of Commerce, GOI in New Delhi, and should have been consulted on this important policy decision. So, my lords, my contention is, and it is also supported by the respondent number 4, who's the BIS authority, the marking certification or agency, that this is an issue of policy, my lords. That's point number 1. Point number 2, my lords, kindly see the affidavit of BIS, my lords, which is filed per.
just one second. Yes.
My lords. Secondly, the question as to whether a certification process is to be done or not is an issue which is to be dealt, it's a scientific and technical issue, my lords, which is best dealt with by the experts. And in this particular case, expert committees were made up, my lords, opinions were taken, and based on that, the certification as far as phenol is concerned, my lords, was determined. And they say so in para 8, my lords, of their additional affidavit. I'll show that, or my lords, let the respondents take it. 4th point, my lords, and again another point. I still don't understand what is my learned friend client's grievance, my lords. They are manufacturers of plywood. My lords, he says the manufacturers sitting abroad should not take registration and a license from the government of India under the BIS registration. my lords. Now, as I told lordships, your lordships, my lords, the draft notification or the draft order was sent to all the member states for comments of the various manufacturers. These manufacturers is not commented. So they are okay with the broad framework of the act, my lords. So I don't understand what is the locus of my learned friend to say the manufacturers will have a difficulty, my lords. It doesn't fall on him, my lords, to say that they will, it's again a very presumptive argument that they will have a difficulty, my lords. And my lords, just for your lordship's convenience and assistance, there is a direct judgment of Justice Pardiwala, my lords, sitting as he was then before the Gujarat High Court, directly on the point, my lords, in a BIS matter. I had given my learned friend a copy last time. Justice Pardiwala judgment.
I don't know whether your lordship is allowing the intervener to place all the judgments and all.
No, I'm just assisting the court.
No,
nothing else.
assistance, please. I'm.
So where is Mr. Dev Chaudhary? Is he not appearing? He's out of station.
Yes, lordship, some.
What about the affidavit of the union?
It has been filed.
Everything, readings are complete.
Readings are complete. All right. You keep it with
Very,
yourself now.
very,
We'll see.
very. Next time, my lords.
Can you agree on a date, both of you? No. Agree on a date.
Whatever my learned friend says, my lords, I'll be there, my lords. No difficulty.
No, always.
This is a matter where,
Between mutually, there is no problem for that.
no, I think, see,
जितिया
अपनी इच्छा convenient था.
mutually होगा लगी.
Itu mahonte south Nikumata,
नहीं तो माउंट हो. There is no problem. They all are blocked.
early September. Ma 8 तारीख ahi ase. 8 तारीख
8 नहीं 8
6 तारीख ले लो दादा.
so no so like only one day only.
12 तारीख के कोई ऐसे.
Like from now it go.
13 तारीख ले लो.
14
Is 13th or 14th September.
is the Thursday.
No, but what is the urgency in this matter?
Malad's difficulty is, Malad, this matter has been going on for a long time, Malad.
Mhm.
And this is a short point, Malad. I will not take more.
If your lordship permit me one submission, I might make. If your lordship.
Mhm.
The interim order says that they will not pass the order without taking leave of the court, nothing else.
That's right.
Now, leave of the court, if they want to pass the order, central government will come up before your lordship seeking a leave.
Mhm.
Now,
We'll
beyond
have it
that,
on 19th September.
Very. I will.
Dr. A.K. Saram, senior counsel listed by Mr. A. Goel, has appeared for the petitioner and submits that although this matter has been listed for final hearing and disposal today, yet he is not prepared to argue the matter. As such, a request has been made to post this case for hearing again on 19th of September 2023. Mr. P. Sharma, learned counsel appearing for the intervener stroke respond number 7 is present and has expressed urgency by stating that due to the pendency of this proceeding, the concerned authorities in the government of India have refrained from taking any further action in the matter. Mr. Ms. L. Devi, learned CGC. It is submitted at the bar that the learned DSGI, Mr. R.K. Dev Chaudhary, who is appearing for the official respondents, is out of station and therefore is unable to attend the court proceedings today. Who's respondent number 4? Mr. The learned counsel for the respondent number 4 is present, but does not have any objection if the prayer for adjournment is allowed. In view of the above, and at the request of learned counsel for the contesting parties, this matter is directed to be listed for hearing again on 19th September 2023 as a
but I will be obliged if online is also mentioned because you also mentioned that respondent number 7 has said urgency. You also mentioned my submission that he has no power. Right.
Those are on the merit of the matter. They
But
don't go into all these things.
Below that, your lordship may kindly see below, if either your lordship may not record the respondent number 7 submission, the urgency in the matter. He has no power, right also to make such
Urgency
submissions.
in the matter is, however, Dr. Saraf has retorted by submitting that the respondent number 7 does not have any locus to make any submission in this case. Be that as.
Not submissions, make this submission.
Huh?
Make this submission, you can
Make
support.
the said submission. in this case, be that as it may. On the request of learned counsel for the contesting parties, this matter is required to be, is directed to be listed 19th, etc.
So my learned friend said that many matter that he has not understood how I can make submission. Because similarly, I have not been able to
All
understand.
right, now the order has been passed.
That's why I'm saying.
Now it should cool down.
Sometimes your lordship, this is last item. Your lordship
I don't
went
need to say more, my
Your
lords.
lordship went to chamber. So something will not.
No, that's fine. Mr. Sharma,
Yes,
as you were arguing,
Yes, my lord.
the attention of the court was on something else.
Yes, my lord.
The device in your hand.
Yes, my
What
lords.
are you have loaded the entire files here?
Yes, my lord. Entire file, my lords. I have it only here, my lords.
That even application nowadays.
My lords, it is very convenient, my lords. There are two.
All right, if you don't mind, can you please
Of course,
spend
my
10
lord.
minutes with our person?
Yes, it will be my pleasure. In fact, it was a pleasure listening to your lordships, my lord. The way the lordship comes to the point, it was just phenomenal to understand. And
By hand, it can be marked and thereafter if you touch it, the same page number will come.
No, that's it. We are trying to,
Yes,
at
madam.
least this court is trying to
My
go
lordship is the
paperless
main
yes,
chairman
at
of
the earliest.
yes, my lords.
And
In fact,
every
court
day we
number
are
one in
reading
the Supreme
petitions.
Court now, my lords,
Hmm.
the Chief Justice of India insists that even the senior most counsel, even people senior than Mr. Sibbal, etc., and have everything
So
on.
then that can be taken as a ground.
Yes, well, that's absolutely.
There will be a lot of difficulty. Lot of difficulty.
Well,
not from
everybody
bar
is now.
also.
Don't be surprised, Dr. Saraf, if he takes this as a ground against the.
100%. Next time, I will be ready with that.
Yeah, so therefore.
Yes, my lord. I will
We have
definitely.
been holding meetings regularly.
Yes, my lord.
To see if this court at least can go completely paperless.
Oh, that's really nice.
So
my
a
lord.
little input from you. if
Yes,
you
yes,
like.
of course.
You can also give
On
input.
19th, we will also try that the same thing. We
Yes,
also have
yes,
to do
yes.
before lots paperless.
I think there is a consensus across the country that it's a good idea to go on paperless.
Yes,
With the chairman of the committee. So,
No, we are trying, Dr. Saraf. In fact,
but the problem is they have the outlying
in fact,
benches.
these are not matters to be probably
The
discussed.
outlying benches. In some of the benches, they are not giving the
No,
video.
but there are
facilities.
operational problems. The
Other,
entire networking of this building has gone obsolete. You have to change the entire networking, otherwise it is not supporting
just
paperless court
Correct.
system. The workflow pattern cannot be controlled.
yes, correct.
And we don't want to jump into a decision which poses difficulty for the members of the bar.
It has to be systematically.
Correct. So therefore, the idea is, if possible, this court would like to start it.
Yes, that's a
see how-
lovely initiative.
We would like to address the grievance and issues of everyone.
Well, I
Suddenly-
can say, Malads, after almost a year of doing this, Malads, at least on 2 applications, Malad, I have quite familiar.
You are using
So I'll
good,
pass.
good notes. What are you?
No,
using?
I am using liquid text, Malad.
Liquid text.
This is the best one. that everybody-
Before that, I was using PDF expert, Malad. Both are good. But as a lawyer, from a lawyer perspective, I think liquid text is unmatched.
But from a judge's perspective. maybe
From a
good-
judge's perspective, I think PDF expert would be better because that is what the Delhi High Court, everybody also uses.
PDF experts, so now good notes has come out in versions 5 also.
6,
Version
Malad.
6.
Version 6 is there as far as good notes is concerned.
In that case, all the persons must file also in the PDF.
No, what happens in Delhi, at least, Malad, what we do now, Malad, the court officer would give the entire file as it is with your lordship, Malad, on a pen drive. Then we take it on our iPads or our computers as the case may be. And then based on that, it is all bookmarked. So it becomes
So,
very,
but that is possible when the entire filing is in soft.
we have to do everything, Malad. It's mandatory for us, Malad, today in Delhi High Court, at least, Malad, and the Supreme Court to file e-copies. And then the bookmarking is done by the registry, Malad, now.
Well, for the timing, your lordship may also the liquid but this may start. PDF will take time.
But if the
because
files
giving
are not loaded,
giving
Malad, that is the
pen drive,
difficulty.
Giving to bar and giving all those things may take time. For the timing
That is it, because every place has some
difficulties.
issues.
Yes, yes.
And the committee, ICT Guwahati, the Honorable Chief Justice, we are sensitive that we don't want the lawyers to suddenly face difficulties.
Yes, yes, of course.
Gradually, of course, this is beneficial. Of
Yes.
course, this is the best way. But that mindset has to change.
My lord,
People
it
need
has
to
to be.
adapt.
Absolutely.
So that transition is something we would like to manage.
Yes.
We are
And it
trying
has to be
manage this,
gradual only. Malad. Your lordship is absolutely.
But it
right.
can't be too gradual.
Yes.
also.
Yes.
Like GST, develop technical glitches, all this will start. So unless until the formal full system is there, it is very difficult. And if argues and thereafter meets something,
Let us see, we welcome suggestions, inputs from everyone. It is everyone's
I
system.
think even
We
we
make
from
it-
Delhi will be better able to give all the advice.
Yes.
We are from the
The
Guwahati small
Delhi,
place.
Delhi High Court's e-committee, Malad, had prepared a white paper kind of a.
Delhi High Court, I have seen.
Yes, your
I have
lordship would have
monitored it.
spoken to the judge in charge.
Today itself, we are not we are not in a position to replicate the Delhi model.
Correct, correct.
Because our infrastructure here.
Doesn't
we've-
support.
We've had audits done through
Mhm.
experts, IIT experts, etc. They said that with this infrastructure, nothing can be done.
Well, two-
And to go for new infrastructure,
Cost is also
cost
there.
is there, funds are earmarked under the
Correct.
new committee, e-committee project. But that is yet to roll out.
Supreme Court funds is endless, Malad. Delhi High Court also,
Hmm.
they get whatever they want, especially
Maybe
now.
those are
Yeah.
issues which
Well,
are
Gua-
matter of 1 or 2 months.
Guwahati, Delhi, 2.5 hours flight is there. Some time it will take from Delhi to Guwahati.
So lordship is aware. I mean, lordship would have gone through all of that.
Yes, but one thing is for sure, we are going paperless very soon.
Yes.
Yes, my lord, that
That's
will
a
best.
must.
That will best.
Then I will also tell the court master or your lordship's court, the law clerk, Manods, as to how to upload the files for your lordships. And then the bookmarking process, Manoj. That also I will explain so that whatever file, Manods, so what can be done initially going forward, Manods?
Perfect.
The files that are, for example, a hard copy is filed in the registry. The file can be scanned in OCR PDF. Manoj. So, I mean, the PDF can be done based on an OCR. I'll tell all of that. Then it becomes searchable. Manoj. If you do OCR, then it becomes searchable. Then your lordships will upload it in any of the applications, whatever your lordship is comfortable with, and the bookmarking would be there. So even if the councils here are with the hard copy, your lordships can go digital.
That's the idea.
Yes, Manoj. I will explain that process. Manoj.
And Dr. Saraf, you are getting online certified copies from next week.
Okay.
Online RTA applications and some other features all are being launched next week. So now there will be rollout one after
Well,
another.
it's
But
not-
the problem with the paperless court is that we can't use this
This
infrastructure.
will take some time, my lord, but process has to start.
Everybody, 3-4 teams have examined and all of them have said, sorry.
Because
nothing
step
can-
by step, many things have come out.
So
In Guwahati
we have to
also.
change because the Wi-Fi is not supporting, the landline is not supporting. The gadgets are outdated.
Okay.
My lord, the small rain is there, the light goes, everything goes, my lord, the internet is not there. There is a lot of problem.
That's correct.
It's not like, my lord, when we find that small rain is there, automatically it goes everything.
No, but you see, as they say, there is nothing more powerful than an idea whose time has come.
Correct.
It is time to go digital.
You have to go by. step
And your
by step.
lordships can lead by example. What happened in Delhi, in fact, Justice Badar Ahmad and Justice Bhatt was the persons who actually started this. So seeing them, Malad, everybody started. You know,
Oh, yes,
nobody
yes,
wanted to,
Yes.
you know, so
That's
that is.
the idea.
Yes,
Lordship as a
The
chairman.
Honorable Chief Justice is also very,
very keen. I'm sure, Malad.
Here, your lordship as a chairman is doing a lot of things.
Yes.
Things are coming out.
Let us
And
see.
it will take
let
some
us see.
time, otherwise the process is on. Like
Let us see,
we have improved a lot. The
let us see,
judgments
we
are
are,
coming,
we are trying to make
the
life
judgments are
easier.
coming
Yes, ma'am.
online every
Uh,
day.
What is the idea behind digitization? To make everyone's life easier
My lord.
and to increase the efficiency. Otherwise, why should people do it?
And justice accessible, what it has done, Malad, as a result, today a client whom I could actually go and convince ki matter was argued today. So today he knows the client sitting in maybe Tamil Nadu when I do a matter in the Supreme Court, he sees what is happening in the court, Malad.
Absolutely.
So I can't take him for a ride. I'll exactly have to tell him as a counsel what actually happened.
No, it is not about taking for ride also.
Yes, ma'am.
Every litigant has a right.
Yes, right to know,
what is
Malad.
happening.
He has a right to know and access to justice. So he has
These are
more access to
tremendous
justice.
empowerment and
Absolutely.
thanks to
My
Supreme
lord, your
Court.
lordship may have a study circle or technical meeting seminar.
Mhm.
Mr. Sharma can come and explain.
No, Lordship is aware more than
No,
more
but
than
we'll do.
myself,
These are not taken lightly.
Yes.
We'll do many
That's
things.
why I'm
will-
saying, but I'm saying really in the right spirit. You can come and explain
No,
so that
Suggestion well taken. We'll
people can come to know.
That'd be a pleasure, Malad, but your
we'll
lordship
do
knows.
welcome all suggestions, all ideas.
Virtual we can have, you can explain the virtual.
Yeah, even otherwise I can. It's not
All right, so
very well. Malad, I'll sit.
let us put an end to it. today
Yes.
You may
and
take a
then-
rest and thereafter, not rest, because the committee matters.
All right, anybody else ready with any matter?
I'm obliged.
Huh? Time being matter, call it. Yes. What is
Sorry,
your
my lord,
matter?
at that time I was not, my lord, lordship may kindly peruse order dated 15/6/2023, my lord.
Yes.
My lord,
We have been directed to obtain certain instructions, lordship, whether the paper publication was there or not. And that we have not yet received, but may I suggest Lordship, as because it's a case of 2013, most probably my learned friend will also agree to that. There are certain representations pending before the authorities. If that is disposed of, as because it is a case of that municipal area, the Gaon Pancayat area, Lordship, it was converted to a town committee. So for that,
What is
Lordship, under
the
the
representation? Let us see.
Page 40, Lordship may kindly see.
Page
40, madam. This is submitted before the deputy commissioner. Madam.
he is the competent authority.
forty-eight. It's
40.
40, madam, 40.
40. So you want this Kumar Dihingia Gaon to be excluded from the purview of Demo Town
Town
Committee.
committee, madam.
Lordship, that is. as
That is
because-
the request.
Yeah, as because Lordship, there is a requirement under the municipal act that it should be published.
The notice.
The notice should be published, Lordship, we have, for, if there is any objections from the locality, Lordship. And thereafter, within a period of 4 weeks, it is to be disposed of. Then, Lordship, it can be, but
Which is the
there-
provision? Let us see what is the.
Section 334 of the. Assam
Subsection-
Municipal Act. Assam Municipal.
Assam Municipal Act 1956.
Section 334. Subsection 2, madam.
Section?
Section 334, madam.
Subsection 2.
$334.
Notification মানে দিব দিছি।
The 11th will be subsection 2, madam.
No, so what do the petitioner, who is the petitioner here?
Lord, petitioners are some of the villages, my lord, is there, I have any stated in paragraph 1, my lord.
Hmm.
They are Raisai Kok, Kuar Dingia Gaon, Kok Block, my lord. These petitioners' main grievance is that, my lord. My lord, while constituting the demo town committee, my lord, as per section 334.
So
that,
petitioners are the villagers of this Raichai Kho,
and,
Kumar Dihingia Gaon Kho block.
Yes, my lord.
etc.
Yes.
What do they want?
My lord, they want that their villages should not be included in the demo town committee, my lord.
Hmm.
My lord, what happened, my lord, when the.
Why? Because that way they will develop more.
No, my lord, they are basically dependent on the agriculture, my lord, and there are different schemes like, my lord, Manrega, Indira Awas Yojana, all these are, that will be only for the villages, my lord. If it is
No, no.
included in the town committee, my lord, then
Municipal.
all these schemes will go. Then, my lord, the burden of tax and all these are there, my lord, and this 80% population is below the poverty line, my lord. And my lord, this repetition is basically filed on the ground, my lord. Lordship may kindly come to page number, my lord, 27, my lord, the notification, my lord. Page 27, my lord.
Their contention is that 334 was not complied with.
My lord, this is the notification.
And
published.
in our affidavit, lordship, that.
Three thirty-four two was not complied with before including these villages.
Yes,
my lord.
that
Demo
was
town
it, and in our affidavit, lordship, those annexes were not there. Accordingly, we have been directed to get their instructions whether that notification was published or not in accordance with law. That instructions is still awaited, but my learned friend has stated that.
Then you listen to the order.
Lordship.
If necessary, we'll make changes. Heard
Lordship.
Mr. A.K. Gupta, learned counsel appearing for the writ petitioners. Also heard Mr. H. Sharma, learned additional senior government advocate Assam, appearing for the respond numbers 1 to 4. Full stop. The writ petitioners hearing claim to be the original inhabitants of the villages identified as Raichai, Raichai, Ko, within quotes Ko, comma, within quotes Kho, comma, Kuor Dihingia Gaon, comma, Kho block, Kaliapani, Dighali Bam, Bhabari, and Thanalai villages. Full stop. They are, according to the projections made in the writ petition, the villages of this, of the aforesaid localities are, most of the villages of the aforesaid localities are living below poverty line. Full stop. However, due to the inclusion of the aforesaid villages within the jurisdictional area of Demo Town Committee, these villages have been deprived of various beneficial schemes introduced by the central government as well as the state government of Assam, which includes schemes such as Manrega, Enrega, etc. Full stop. According to the petitioners, the notification to issue to include the aforesaid villages within the Demo Town Committee area was issued without following the mandatory provision of section 334 subsection 2 of the Assam Municipal Act 1956, as a result of which the villagers did not have an opportunity to raise their objections in the matter. Full stop. Mr. Gupta submits that a number of representations have already been submitted by the villagers before the respond number 3, that is the Deputy Commissioner Sibsagar, ventilating their grievance in the matter. However, notwithstanding such recommendation supported by resolutions adopted by the Demo Town Committee. Is it, these are all resolutions of
Resolutions taken by the village people, my lord.
resolutions adopted in the meetings of the villagers. No action has been taken in the matter till today. Hence this writ petition. Full stop. Mr. H. Sharma, learned additional senior government advocate Assam, submits that instructions as called for are still awaited. Full stop. The learned government advocate Assam has, however, submitted that having regard to the nature of grievance expressed in this writ petition, he would have no objection if the matter is disposed of by remanding the same to the respond number 3 with a direction to examine the grievance of the petitioners and, if necessary, initiate fresh action after complying with the requirements of law, more particularly section 334 of the Assam Municipal Act 1956. Mr. Gupta has also agreed to the said recourse. In view of the above, without expressing any opinion on the claim of the petitioners on merit of the case, this writ petition is hereby disposed of with a direction upon the respondent number 3.
Along with the certified copy, they will place this, the representation.
Consider the grievance of the petitioner as reflected in the representation dated 22/1/2013 bracket annexure F series bracket close, and thereafter take appropriate steps in the matter as may be permissible under the law in the light of the observations made herein above, so as to redress the grievance of the petitioners. Facilitating the above, the petitioners to produce a certified copy of this order along with copies of the representations annexed to the writ petition within a period of 4 weeks from today, so as to enable the respondent number 3 to take appropriate action in the matter. Writ petition stands closed. Part 2, Asam, original, no other matter is there. Then I'll have to rise.
Maksud. Yate aro erakon nai.